forward with strength and resolve to make sure that a program like this never happens again. Would you commit to this committee that you will read the classified version of the report's findings and conclusions if confirmed as General Counsel?
Yes, Senator Feinstein, I'd be particularly interested in the parts of the report that address the General Counsel's office.
Thank you. But that's just a small part of the report.
I'll commit to the whole thing, but those are where that would obviously be where my focus.
It's a long read, but if you look at things like where the agency has detailed 25 cases where they believed it was responsible for their apprehension, the report in classified version details where the information actually came from that led to that. And I feel very strongly that the time is coming for this report to be declassified, that it should not be hidden, that people in government ought to read it, people in areas of responsibility ought to read it, and to shy away from it because it is an official document now. I think it is a mistake. As you know, President Obama did put it in his library, so at least it's perpetuated there. Second question, use of contractors. This is one of the things I have been most concerned with. And not the least was, it wasn't lost on me that 3 big cases where materials disappeared and security was broken were done by contractors. And including the largest one ever, Edward Snowden, and more recently, Hal Martin. Previously, when I was chairman, I worked with Director Panetta, and he had agreed to a decrease of a certain % every year in the number of contractors, and the number of contractors has gone down. Government contractors are only supposed to be used if they are performing tasks that are not an inherent governmental function. So intelligence collection clearly is inherently governmental as a function. And I think that we need to continue to reduce the number of contractors. The question I have for you is, do you agree that intelligence work is clearly an inherently governmental function?
Senator Feinstein, you raised an excellent point, and it does sound like a core government function to me. And I think you raise a very important issue with respect to the use of contractors.
Thank you. I agree with that, and I have, my time has expired. Thank you, Mr. Chairman.
Senator Cornyn.
Ms. Elwood, welcome, and congratulations to you and your family on this tremendous honor. I know you've been asked about the Russia investigation by Senator Warner, and I would just suggest that the same challenge that you and Director Pompeo will face, and the importance of your integrity, your resilience, and your courage in withstanding outside pressure, the same sorts of characteristics I think are going to need to be demonstrated by this committee to maintain the bipartisan leadership that Chairman Burr and Senator Warner have provided, because there's going to be an awful lot of people who are going to try to influence this committee and get us off track. So the same challenges to our integrity, resilience, and courage to resist pressure from outside groups that you'll be having to demonstrate, we will as well. I want to, you've been asked a lot about post-9/11 interrogation and other practices. It really is kind of amazing to me that here we are 16 years after 9/11. The chairman mentioned 7 years, I think, since some of the practices that have been asked about have long since ended, where we continue to revisit these decisions which were made, I think, consistent with the appropriate legal authority at the time. I'm very troubled by the idea that you, as the General Counsel, and the lawyers in the administration are going to be telling intelligence officers, you can do this, you can't do that. And if consistent with legal authority that you identify, they do something that later on they're going to be criticized, perhaps for political or other reasons for doing what is legally authorized. So can you tell us who is the final legal authority on the scope of activities of the Central Intelligence Agency?
Well, ultimately, under longstanding 18th century precedent, the Attorney General is the ultimate determiner of the scope of, the legal authorities by any government agency.
And that's because these cases don't go to court typically, right?
Generally not.
There are, of course, exceptions, the Hamdan case and others where there is the Supreme Court, but I think this is an area where people are somewhat confused. They think that this is black letter law, and often it's a matter of legal opinion by the Office of Legal Counsel at the Attorney General's office.
Yes, sir, Senator. And as I was alluding to in my conversations with David Criss, on many of these complex issues, there is a range of reasonable interpretations, and the Department of Justice or the lawyers being asked to provide an opinion give their best reading of the law. But it doesn't mean that there can't be another interpretation that is reasonable, but the Department of Justice ultimately gives its best reading of the law.
And just because somebody disagrees with a legal opinion doesn't mean that the authorities that you've identified or that other lawyers in the administration identify as conferring that authority, doesn't mean that's wrong either, does it?
That's true. Yes, sir.
So I think this is a real problem for the intelligence community because, as I mentioned during Director Pompeo's confirmation hearing, I like General Hayden's book and concept of playing to the edge. But you're going to be the one that draws that line of demarcation and identifies where that edge is. And if intelligence officers play to the edge in order to maintain our national security here in the United States, I don't want them to be criticized later on or taken to court, publicly humiliated, or even forced to buy liability insurance for doing their job.
Yes, Senator, as part of this process, in preparation for it, I reviewed the transcripts of some people who were nominated to this position, and I noted that some of the senators were stressing the importance that the lawyers go to the legal limits. So, back not that many years ago, the lawyers were being criticized for being too conservative.
Right. Well, post 9/11, we didn't know, as a nation, certainly didn't know as a government, whether there are going to be follow-on attacks. And so you were under a tremendous, or the agency and our intelligence officials were under a tremendous pressure by members of Congress and others to go as far as you legally could, correct?
Yes, sir, absolutely.
And I guess it's just human nature that in the safety and security and after the passage of years when we don't feel this imminent threat, then we somehow decide, well, maybe we didn't have to go as far as we did. So, well, I appreciate your answer to the questions, and I too believe that you are eminently qualified for this position. Thank you for your willingness to take it on. Thanks to your family for their support.
Thank you, Senator Cornyn.
Senator Watt.
Thank you, Mr. Chairman, and Ms. Elwood, thank you for our meeting as well. I join my colleagues in appreciating that. During his confirmation process, I asked Director Pompeo about what he considered to be the boundaries that apply to the surveillance of Americans. He said those boundaries are set by law. You are the nominee to be the General Counsel, who, if confirmed, would advise the director of those boundaries. Because the advice is classified and may not even be known to the committee, it's critical that we get a sense of your views on the law prior to voting. So to me, one of the most important legal matters facing the agency is how it should handle large amounts of information on Americans who are not suspected of anything. I also asked Director Pompeo about this. He said he would consult with a lawyer. And so to speak, now the committee gets to ask the lawyer. You have written that the Attorney General guidelines governing collection on 12-333 would impose, and I quote here, stringent and detailed restrictions on big batches of information that include information on Americans. I read the guidelines differently. The CIA can actually conduct searches of those batches looking for information on Americans. So my question to you deals with the statement you gave us. What stringent restrictions specifically are you talking about?
Senator, as you know, the Attorney General guidelines are publicly available, and they were recently revised, and they are public. They're not a secret.
I want to know what you consider to be stringent restrictions.
There are numerous restrictions, and it depends upon the particular information at issue. So there are obviously less stringent use and retention requirements with respect to publicly available information. But even there, if it's U.S. person information, still the CIA's use of it is restricted. And then it's a 30-page single-spaced document providing a framework.
Give me an example, because the way I read it, none of this changes the fact that the agency can conduct searches looking for information on law-abiding Americans where there is no requirement that they're suspected of anything. So I'd just like to hear you tell me, since you stated it in writing, what stringent restrictions would protect that law-abiding American?
Well, for example, Senator, before certain information is queried, it has to, the standard that is applied would restrict. It is not simply they can't go in and query anything they want. It has to begin for a necessary to authorized activity. So for the purpose of an authorized activity, and no further query with respect to publicly available information can't go any further than the necessary extent to further that purpose. Now, with respect to different categories of information that are collected under different authorities, 702 has a different query standard, as you know, than a bulk collection of information collected under 12333. And I don't want to give the inarticulate, or I don't want to be inarticulate about the standards. I want to be precise, and they are spelled out in a public document. So
none of this, and I'll hold the record open for this. I'd like to just have you give me some concrete examples of.
I'm happy to do that when I
but
look at the exact
But the point is,
words.
the answer we've gotten this morning is none of what you have said changes the fact that the agency can conduct searches looking for information on law-abiding Americans where there is no requirement that they're suspected of anything.
Senator, there has to be a link to an authorized activity of the CIA at a bare minimum, even to search publicly available information. There are far more stringent requirements with respect to collections depending upon the type of information is involved. So I don't agree with you, Senator, that there's no restraint on it.
You get me the example of the stringent restrictions. Let me see if I can get one other question in very quickly. The agency spied on the committee in 2014, searching our computers. They turned around and filed a crimes report with the Department of Justice against committee staffers. The Inspector General found there was no basis for the crimes report, and it was based solely on inaccurate information provided by 2 attorneys from the CIA's Office of General Counsel. You, if confirmed, would be supervising those attorneys. Do you think there ought to be any accountability?
Senator, I understand there was an accountability board convened that looked at that issue already and exonerated the lawyers involved.
But do you believe there should be any accountability when those lawyers who would be under your supervision provide inaccurate information?
Senator, I understand there was already an independent accountability board.
I'm not talking about the past thing. I want to hear about what you do going forward.
Oh, certainly. Going forward, I would, if there was a situation like that to arise again, and if the facts presented themselves in a situation where the lawyers had not done something properly, absolutely, I would insist on accountability and proceed accordingly. But that's going forward, yes. I'm not revisiting the past.
Thank you for the time, Mr.
Senator Heinrich.
Thank you, Mr. Chairman, and thank you for joining us today, Ms. Elwood.
Hi.
In reviewing your responses to committee questions, there was one theme that concerned me across your responses. and it's that you repeatedly repeat some very similar verbiage, and I want to get this right, but you said at one point that you have not, quote, had personal experience with, end quote, issues raised by the committee. You, quote, have not previously had the opportunity to consider, end quote, issues raised by the committee, and that you have not, or that you have, quote, not done the legal and factual research that would be required to properly answer, end quote, important questions such as whether the CIA's former enhanced interrogation techniques are consistent with the Detainee Treatment Act. So, as you know, in this role, you will be the principal legal advisor to the CIA director, and you will be responsible for overseeing the CIA's Office of General Counsel. If confirmed, I hope that your lack of exposure to the important national security issues that we've raised will not encumber your ability to provide thorough, accurate, and effective legal advice to the CIA from day one. So I want to go from here, since you didn't express strong opinions on some very specific questions that the committee has asked. I'd like to focus more broadly on the scope of authorities granted by covert action authorizations and by presidential memorandums of notification. And as I'm sure you know, these authorizations spell out the strategic goals and approved activities of individual covert actions. Is it your view that the authorized covert actions of the CIA are bound by the text of those authorities, and that the CIA may not read into those authorities activities that are not explicitly approved within there?
Senator, I assume that there is vigorous oversight by the General Counsel's office to ensure that the findings are written carefully and that the activities undertaken under the findings are consistent with the findings. Is that, I'm not sure I understand your question.
What I'm saying is that they, it is my interpretation that those activities have to be explicitly authorized within either a covert action authorization or a presidential memorandum of notification. So is it your view that the authorized covert activities of the agency are bound by the text of those authorities in terms of explicitly authorizing activities, or can the agency just read into those authorizations?
I would interpret it as a statute, which is that it would not necessarily have to be explicit, that every potential action be explicitly stated in the findings, but that would have to be a proper interpretation of the findings.
I'll give you an example that concerns me, the September 17, 2001 memorandum of notification that authorized the CIA capture and detention program, for example, made no reference to interrogations or to coercive interrogation techniques, yet it was repeatedly cited by the agency as the foundational authorization for that interrogation program. So just putting aside the bigger issues of whether the interrogation techniques themselves were in violation of any laws or treaty obligations, based on the lack of explicit authorization for those techniques in the MON, do you believe that the use of those techniques were consistent with the approved authorities as it was written?
Senator, I have neither looked at that particular MON or do I know anything beyond the executive summary of the Senate study to answer that question specifically. But I believe that these are a fair reading of the, nobody has raised that that was not a fair reading of the notification.
Well, I'm raising it.
Right.
So whether or not you've reviewed it isn't relevant to my underlying concern. When the committee receives a covert action finding or a MON, we need to be confident that the agency is not exceeding its approved authority. So if you can't give us your view on the proper scope of covert action authorities as a basic principle, it's difficult for me to be confident that under your legal guidance, the agency won't engage in activities that go beyond that legal guidance.
It is a common practice in my 20 years of legal experience and also my experience as a clerk to have a statute or a rule of law provided. And you're not going to have a statute describe every possible activity to fall within the scope of the statute, but there could be a fair reading of the statute that would put things within the statute or without the statute. And I would envision the same sort of legal analysis that I've been doing for more than 20 years would apply in the context of a memorandum of notification.
I'm going to yield back my time. It says I've exceeded it, and I assume we're going to go to Senator King of Maine, since we're the only,
Since I'm the acting chairman,
Right.
Senator King.
Thank you. I didn't see you over there, Senator Cornyn.
Thank you. Ms. Elwood, thank you very much. Welcome to the committee. You started your introductory by talking about your dad's experience with military history, and I want to commend to my colleagues, I'm in the middle of H.R. McMaster's book about Vietnam, Dereliction of Duty, which I find an extraordinary document with really important insights. I have to mention, you've given me an opportunity to mention what I think is a very important book that should be read by everyone up here.
Yes, sir. I understand that's now being taught in the officer training course.
And I hope General McMaster is also rereading it himself, given his new position. In your answer to, I think it was Chairman Burr's, one of his opening questions, you said that you thought the 2007 law strengthened the legal basis for the terrorist surveillance program. That implies, does that imply that you believe that there was a legal basis for it? In other words, does the president have inherent Article II power to do warrantless surveillance of U.S. citizens?
Senator, the legal authorities underpinning the terrorist surveillance program as described in the public white paper I reviewed and then in the much longer, then classified but largely declassified opinion of OLC did not rest entirely on the president's Article II authorities, but also rested first on the authorities provided by the AUMF. As
Right, the 2001 AUMF.
Yes, sir.
Let's exclude that for a moment. Do you believe that the president has inherent authority under the Commander-in-Chief provision of Article II to